Environment Impact Assessment.
Environment Impact Assessment, EIA, is a study to predict the impact of a proposed activity on the environment as a decision-making tool. EIA compares various alternatives for an activity or project and seeks to identify the activity or project which is the best combination from economic and environmental costs and benefits point of view. The assessment is done in different forms, such as Health Impact Assessment, HIA, Social Impact Assessment, SIA, etc., to assess the health and social consequences of development along with the environmental assessment. Strategic Environment Assessment, SEA, is a systematic analysis of impact of development policies, plans, programs and other proposed strategic actions on environment. SEA is a proactive approach for integrating environmental considerations to next levels of decision-making. As a signatory to the Stockholm Declaration on Environment 1972, India enacted laws in 1974 to control water pollution and air pollution. In 1981, the Bhopal gas leak tragedy in 1984 paved the way for enactment of an inclusive Act for Environmental Protection in the year 1986. Subsequent to the Environment Protection Act, 1986, in the year 1994, India proclaimed EIA norms, as per which, any activity or project which intends to access, utilize, and affect, pollute, natural resources has to go through the EIA process and obtain environmental clearance before coming into being.
The EIA norms notified in 1994 were revised in 2006 incorporating amendments, court orders etc. The EIA is one of the successful policy innovations of the 20th century for the conservation of the environment. EIA as a mandatory regulatory procedure originated in the early 1970s, with the implementation of the National Environment Policy Acts by different countries both developed and developing. In India, the process began relatively later, when the Planning Commission requested the Department of Science and Technology to examine the River Valley projects from environmental angle in the year 1976-77. In January 1994, the Union Ministry of Environment and Forests, MEF, promulgated an EIA notification making environmental clearance mandatory for expansion or modernization of any activity or for setting up of new projects listed in Schedule 1 to the notification. Subsequent to the issue of the notification, 12 amendments had been made. The Ministry of Environment and Forests notified a new EIA legislation in September 2006, according to which, it became mandatory for projects such as mining, thermal power plants, river valley, infrastructure development activities such as roads, highways, ports, harbors, airports etc., and industries including even small electroplating, foundry units etc. to get environment clearance. In the new legislation, the responsibility for clearance of projects was with the state governments depending on the size or capacity of the project. The Ministry of Environment, Forests and Climate Change, MoEFCC, has published the latest EIA notification dated 23rd of March 2020 on 11th of April 2020. The time frame available for the public to send their views, comments, recommendations and objections was 60 days initially. Later, as per the directives of Delhi High Court, the timeline has been extended up to 11th August, 2020. The two significant changes in the new EIA draft notification are, the provisions relating to post facto clearance of projects and abandoning of the public trust doctrine. Existing projects or activities, which are violating the norms of EIA, can now come forward, suo motu for post facto clearance. In case of violations, a violator gets remediation through Environmental Management Plan, EMP. As per the plan, in cases of violation reported by a government authority or by the regulatory authority processing an application, the appraisal committee will make the violator liable for remediation and resource augmentation, equivalent to 2 times the ecological damage and the economic benefit derived through such operation. In case of suo motu applications by the violator, the remediation plan and resource augmentation will be equivalent to 1.5 times the ecological damage and economic benefits derived. For submission of delayed applications, the violator pays a fee of Rs 2,000 to 10,000 per day for the period of delay. As per the draft EIA, some of the specified activities permissible under the Coastal Regulation Zone Act, 1991 would also require to get clearance. Agencies operating in India such as the World Bank, ADB etc. have a set of norms for giving environmental clearance to projects funded by them. The Supreme Court of India in April 2020 opined that, environment law cannot countenance the notion of an ex post facto clearance. This would be contrary to both the precautionary principle as well as the need for sustainable development. The new draft notification states that violations can be reported by the government or by the project developer and not by citizens. According to the new EIA draft notification, cases of violation will be dealt with based on suo motu disclosure by the developer. This would amount to total reliance upon the project developers to disclose when they had broken the law. The new draft notification exempts a number of projects from the ambit of the EIA. Clause 26 of the EIA draft notification specifies 40 different types of industries which are exempted from taking prior environmental clearance. This includes projects termed as strategic by the government. The draft notification states that, in case of strategic projects, no information about the projects would be made available in the public domain. Linear projects such as roads and pipelines in border areas are also exempted from the list. The border area is defined as area falling within 100 km aerial distance from the line of actual control, LAC, with bordering countries of India. Construction projects up to a limit of 150,000 square meters and all inland waterways and national highways projects have also been exempted from taking prior environment clearance. The arguments against the new draft notification puts that, the new draft EIA notification makes it easy for the industries to escape environmental accountability. The conservationists' version of opinion is that, the new draft notification reduces the scope of the EIA and fundamentally diminishes its effect due to the reclassification of industries that are not required to take environmental clearance, thereby limiting public engagement and normalizing environmental violations. Project developers on the other hand express that the new draft EIA notification would dampen the spirit of liberalization and might lead to red tape and rent-seeking. Optimistic Views puts that, the new draft EIA would promote growth of economy through removal of restrictions. The regulatory mechanism, when suitably strengthened, should be able to take care of the environment violation aspects.